Good evening, listeners. Good evening, clients. Greetings from Horizon Properties team, the real property merchants. We are back to our topic relating to the relation between the landlord and the tenant of business premises. Having concluded matters dealing with the landlord and the tenant of a dwelling house, we embarked on the topic of the relationship between the landlord and tenant of business premises. As I guided and indicated that it's very important for real estate service practitioners to understand some of the legal aspects relating to leases, because you cannot separate the properties transactions from the legal aspect of it, because property is legal in nature. I indicated that this relationship is guided by law, Cap 193 of the laws of Zambia. Please take this. Please note that I'm not giving legal opinion. I'm giving experience and expertise as a result of practice and understanding. Cap 193 is referred to as Landlord and Tenant Act Business Premises. The objective of this act is to provide the security of tenure for tenants occupying property for businesses, professional and certain other purposes to enable tenants to obtain new tenancies in certain cases, and to provide for matters connected therewith and incidental thereto. Because last Tuesday we discussed a number of issues relating to this relationship, and I took you through some of the pertinent issues that you should look out in a lease agreement. I also indicated that lease agreements for business premises, they are more detailed than those of dwelling houses. I got a few questions to answer relating to this relationship between landlord and tenant of business premises. Question number one: how much time is needed to be notified as a tenant by the landlord for termination? Question number two: what are the justifiable reasons for termination? Because some landlords just wake up and order tenants to give vacant possession. Is subletting acceptable if you are renting a shop or an office? Question number four: I have a dispute with my landlord in court, and we are still occupying the shop. I cannot disclose the details of the case. Do I have to continue paying rent? Question number one: the time, as I mentioned, the leases of obligations depends what you have agreed with the landlord. However, the Act provides notice of 6 months. You need to be given a notice of 6 months. As you connect this notice, legal notice of 6 months, you connect it also to the objective of the Act is to provide security of tenure. Therefore, in the 6 months it's being given, it allows you to look for other premises and also to notify your clients of your new location. That is when you haven't agreed in the lease on specific period of notice. So that is the way to go. So if you don't have a lease and you're occupying a business premise, you need 6 months. Some of the justifiable reasons for notice to terminate the lease with business premises. It could be repairs and maintenance. you are not maintaining the building and it is losing its value. Delay in payments, substantial breaches of the tenant's agreement, alterations. If you have got alternative alterations of the accommodation, sale of property. If the landlord is going to sell the property, you can be notified for termination. If there's demolition or reconstruction, the lease may be terminated. So those are some of the reasons where your lease may be terminated when you're occupying a shop or an office or warehouse. Is subletting, question number 3, is subletting acceptable? Subletting is acceptable with the justification, with the notification to the tenant, to the landlord. However, there will be conditions, requirements for the landlord to know the people you are subletting to and the conditions, how much you are getting, and whether the people you are subletting to, they're actually operating from that shop. So there are conditions within which you may be allowed to sublet. But this is with a notice to the landlord. The landlord will request for information relating to the subtenants. However, if you are making more money, the subletting is, you are getting more money than the principal is, the landlord may object. There has been this question, it has been a number of tenants use this court action to stop paying rent. However, be notified that when you have a matter in court with the landlord, you continue to pay rent until the matter is disposed of. What also the information I want to deliver to you, that when you are occupying the business premises, the landlord must have justifiable reason why they should not renew your lease. In an event that there's no justifiable reason, you could get a lease through court, and because it's very important that a business remains stable, and therefore there must be a justifiable reason why your lease is not renewed. So therefore, you may get a lease from court, and you may oppose. Between 2 months, you have to notify your landlord 2 months before the end of your lease. Certainly is known that 2 months that I will oppose the termination, and therefore it means if you are going to oppose the termination, it means it's a court action. So you continue to be in the premises as you wait for the outcome of the court action. And in an event that you are awarded a lease through court, the lease, if the terms are coming from the court, they will be reasonable and to both sides, the tenant and the landlord. And next week we'll continue. I will try to guide you how you are able to reasonably negotiate for a lease, for a commercial lease, and you should understand how you should negotiate for a lease. As I said, the understanding of a commercial lease, it means very important that you may need to engage a legal practitioner, because the leases in this relationship for business premises is quite wordy and worded, and you need to the proper understanding. So next week I will take you through how to negotiate favorably for a commercial lease.